It is usually late at night when the thought of justice feels most present, when the noise of the day settles, when voices fade, and only unfinished thoughts remain. That is when people begin to sense that something is not quite right. Justice, for most of us, does not arrive as a judgment read aloud. It arrives as a feeling, a quiet awareness that something fair should have happened, but did not, or that something unfair did, and there was no one to hear it. Many people live their entire lives without ever entering a courtroom. Yet, very few leave without experiencing injustice. A delayed payment, an unanswered complaint, a promise quietly forgotten, a rule applied differently depending on who is asking. The law exists. The system exists. But the feeling lingers that justice somehow remained out of reach. There is a particular kind of frustration that comes from waiting. Waiting for a response. Waiting for acknowledgement. Waiting for someone, somewhere to say, "This matters." Not loudly, just clearly enough to be felt. Often, the waiting is longer than the event itself. Days stretch into months. Months into years. And slowly people stop waiting actively. They learn to carry the weight instead. In everyday life, injustice rarely announces itself. It does not always arrive as an outrage. Sometimes it comes as silence. Sometimes as indifference. Sometimes as a door that never quite opens, no matter how long one stands there. What unsettles people most is not the absence of laws. It is the gap between what exists on paper and what is lived in practice. Between what should happen and what actually does. Between expectation and experience. Even when rules are followed, something can still feel wrong. Even when procedures are complete, something can remain unresolved. Because justice, as people experience it, is not only about outcomes. It is about recognition, about being seen, about being taken seriously, even briefly. There is a human expectation that runs deeper than legality. A hope. A hope that effort will be noticed. That honesty will count. That patience will be met with fairness, not endless delay. This expectation is quiet, but persistent. When it is unmet, people do not always protest. Often, they simply withdraw. They lower their voice. They stop expecting too much. They adjust their lives around the absence of fairness. This is how injustice becomes ordinary, not dramatic, not explosive, just present enough to shape decisions, relationships, and trust, just constant enough to feel normal. And yet, the idea of justice refuses to disappear. It remains larger than verdicts, larger than institutions, larger than formal resolutions. It lives in daily interactions, small decisions, and unspoken hopes. In how people queue, in how they wait their turn, in how they explain themselves again and again, hoping this time it will be enough. In how they tell their children what is fair, even when they themselves have not experienced it. Justice, in this sense, is something people carry with them, quietly, sometimes heavily, sometimes with hope, sometimes with resignation. This episode is not about courts. Not yet. It is about that quiet space where people sense fairness before it is named, where they feel injustice before it is argued, where justice exists not as a rule but as an expectation, a fragile one, a human one, and one that does not sleep easily at night. When people speak of justice in this country, they are often speaking past one another. One speaks of fairness, another of survival, another of dignity, another of voice, and somehow all of them are speaking of the same thing. It is worth remembering that when the Indian Constitution imagined justice, it did not imagine it narrowly. It did not see justice as something that would appear only at the end of a legal process. It imagined justice as something that should quietly shape daily life, long before any dispute reached a courtroom. There was an understanding that freedom alone would not be enough, that rights written on paper would feel incomplete if everyday life remained unequal, that justice had to touch how people live, earn, speak, and participate, not as an announcement, but as an atmosphere. Justice, in this vision, was never meant to belong only to lawyers or judges. It was meant to belong to streets and homes, to workplaces and classrooms, to markets and villages, to places where people rarely use constitutional language, but constantly live constitutional realities. There is a reason justice was imagined in more than one dimension, because injustice rarely arrives in only one form. Economic insecurity quietly shapes choices. Social exclusion erodes confidence. Political invisibility makes voices feel small. Each feeds into the other, often without being noticed. When a person struggles not because of lack of effort, but because the ground beneath them is uneven, justice feels absent. When work does not lead to dignity, justice feels distant. When participation feels symbolic rather than real, justice feels hollow. The constitutional promise was not to eliminate hardship. It was to ensure that hardship did not become destiny, that birth would not decide worth, that circumstance would not permanently silence voice, that power would not remain unanswerable. This promise was never loud. It was never dramatic. It was written with an awareness of time, an understanding that societies change slowly, that habits outlive laws, that fairness needs patience, not just proclamation. Equality in this vision was not sameness. It was balance. An attempt to recognize difference without turning it into disadvantage. An effort to ensure that dignity did not depend on privilege. That respect was not reserved for a few. Dignity itself was understood not as a reward, but as a starting point, something every individual carried, even before being recognized by the system. Justice, then, was about aligning institutions with that inherent worth, about reducing the distance between what people are and how they are treated. In everyday democratic life, this promise appears in small ways, in the expectation that officials will listen, that processes will be predictable, that reasons will be given. That power will explain itself at least sometimes. It appears in the belief that one can question without fear. That disagreement is not disloyalty. That participation does not end at voting, but continues in attention, scrutiny, and conversation. The Constitution did not imagine citizens as passive recipients of justice. It imagined them as participants in sustaining it through patience, through engagement, through insistence, even when tired. This is why justice, in the constitutional sense, is not finished when a law is passed, or when a scheme is announced, or when an institution is created. It begins there, but it does not end there. Justice lives in implementation, in follow-through, in whether promises travel beyond speeches into lived reality, in whether systems adapt when people fall through them. There is also humility in this vision, an acceptance that justice will always be incomplete, that it must be revisited, questioned, corrected, that democracy is not a destination, but a daily negotiation. At night, when people replay their day, they are not thinking of doctrines. They are thinking of how they were treated, whether they were heard, whether their effort mattered, whether the system felt human, even briefly. The constitutional idea of justice meets people precisely there, in that quiet evaluation of fairness, in that sense of being included or excluded, in that fragile trust that tomorrow might be slightly better than today. Justice, in this sense, is not something that descends from above. It is something that must be continuously held up by institutions, by citizens, by the willingness to believe that fairness is not naive, even when it feels distant. And perhaps that is why this promise endures, because it was never only legal. It was moral. It asked not just what the state can enforce, but what society should aspire to. It asked not just for obedience, but for care. A promise quietly woven into everyday democratic life, waiting to be noticed, waiting to be claimed, waiting patiently, like so many who believe in it. Courts occupy a special place in the public imagination. They are where disputes finally arrive when every other door has closed, where words are recorded, reasons are demanded, and power is asked to justify itself. There is comfort in knowing that such a place exists. The presence of courts reassures people that justice has a formal address, that there is a room where arguments are heard instead of silenced, that decisions are not made entirely in private, that authority can be questioned without permission. In India, the Supreme Court of India has often carried this hope, not only as an interpreter of law, but as a guardian when other systems failed. When voices were ignored elsewhere, people found a way to speak through petitions, letters, and pleas. Over time, the courtroom became more than a legal space. It became a place where everyday suffering could be translated into constitutional language, where dignity could be argued for those who never expected to stand before a judge, where injustice, once dismissed as routine, could be named and examined. This expansion mattered. It reminded people that justice could be compassionate, that the Constitution could listen to those without resources, that the law could stretch itself to meet lived reality rather than remain distant from it. And yet, even with this generosity, courts remain limited. They are powerful, but they are not everywhere. They cannot hear every story. They cannot heal every wound. They cannot reach every person in time. Access itself is uneven. Distance, cost, language, and fear stand between people and the courtroom. For many, approaching a court feels intimidating. Not because they lack a case, but because they lack familiarity. The process feels foreign, heavy, and slow. Delay adds another layer. Justice promised tomorrow can feel like injustice today. Years spent waiting drain energy, resources, and hope. Even when a favorable judgment eventually arrives, it often arrives after the damage has already settled. There is also an emotional distance that law cannot always bridge. Courts speak in reasoned language. They must. But suffering is not always reasonable. Pain does not arrive neatly framed. Loss does not wait for a procedure. A judgment can acknowledge harm without undoing it. It can recognize dignity without restoring what was lost. It can be correct and still feel incomplete. This is not a failure of courts, but a limit of their nature. Public interest litigation tried to narrow this distance by allowing issues to reach the court without traditional barriers, by treating collective suffering as worthy of attention, by responding to letters, reports, and cries that did not fit standard formats. Through this, courts touched lives far removed from the courtroom. They spoke of clean air, humane conditions, livelihood, and privacy. They interpreted dignity broadly as something that followed people into their daily struggles, not just as a word, but as a lived expectation. These moments matter. They show what courts can do when imagination meets responsibility, when law listens carefully, when justice becomes less about technical victory and more about human impact. But courts were never meant to carry justice alone. They were not designed to replace administration, policy, or social reform. They intervene, they correct, they remind. They do not govern daily life. If every injustice must travel to a courtroom to be resolved, something else has already failed. Justice, delayed to that extent, becomes fragile. Dependence on courts alone places too much weight on a single institution. Perhaps the most honest way to see courts is this: they are essential, but not sufficient. They are powerful, but not complete. They protect justice at its edges, not at its source. Justice, ultimately, must begin earlier, before harm accumulates, before silence hardens, before people stop believing that fairness is possible without litigation. Courts remain a last refuge, an important one. But justice cannot live only where robes are worn and orders are pronounced. It must also live where people do not know legal language, but still know what feels right, where fairness is expected even when no judge is watching. Delay has a particular sound. It is not loud. It does not announce itself. It sounds like unanswered questions, postponed dates, and promises that keep shifting forward in time. For those who wait, justice does not feel denied immediately. It feels suspended. Life pauses, but time does not. Days move on, responsibilities pile up, but the dispute remains unresolved, quietly shaping every decision. People learn to live with uncertainty. They hesitate before making plans. They avoid change. They carry a case number in their mind, even when they are at work, at home, or trying to sleep. Waiting becomes a condition, not an exception. And slowly, the waiting itself begins to wound. In theory, justice is something that arrives at the end of a process. In lived reality, justice is something people need during the process. They need clarity. They need movement. They need to feel that time is not being wasted without reason. When cases stretch across years, the original issue often changes shape. What began as a dispute becomes a burden. What began as hope turns into fatigue. What began as a demand for fairness becomes a quiet desire for closure, any closure. There is a cost to this waiting that cannot be measured easily. Relationships strain. Resources drain. Confidence erodes. People begin to doubt not just outcomes but the system itself. The law has long recognized that time matters, that justice delayed touches dignity, that prolonged uncertainty affects how people live, work, and imagine their future. This recognition has appeared repeatedly in the voice of the Supreme Court of India, not as an abstract concern, but as an acknowledgement of human suffering. Judges have spoken of pendency not as numbers, but as lives caught in between, of cases that outlive the very disputes they began with, of litigants who grow old waiting for answers that were once urgent. These observations are not accusations. They are reminders that the system is human and therefore vulnerable to overload. That institutions built to deliver justice can also unintentionally delay it. For those inside the process, delay does not feel neutral. Each adjournment carries emotional weight. Each new date resets expectations. Each postponement asks people to keep holding on a little longer. Even those who eventually succeed often speak of exhaustion rather than relief. Victory feels muted when it arrives too late to restore what was lost, when years of stress cannot be undone by a single order. Delay also creates inequality in subtle ways. Those with resources can endure waiting better. They can afford lawyers, time, and emotional distance. For others, delay is punishing. It forces compromises. It discourages persistence. It teaches silence. There is also the quiet fear that comes with prolonged disputes. Fear of being forgotten, of being reduced to a file, of becoming part of a backlog rather than a person with a story. In such moments, justice stops feeling like a right, starts feeling like endurance, like a test of patience rather than a promise of fairness. And yet, people continue to wait. They show up. They sign papers. They attend hearings. Because giving up feels worse than continuing, even when continuing hurts. This persistence says something important. That belief in justice survives delay. That hope, though tired, does not disappear easily. That people still expect institutions to eventually respond. But delay leaves its mark. It teaches caution. It teaches lowered expectations. It teaches people to measure justice not by ideals, but by survival. To speak of justice, then, is also to speak of time. Of how long people are asked to wait for what should feel immediate. Of how uncertainty reshapes lives more deeply than final outcomes. Justice, when it comes too late, is still justice in form. But in experience, it carries scars. Scars of years lived in suspension, of lives paused not by choice but by waiting. Perhaps that is why delay feels so close to injustice, because it asks people to carry uncertainty for too long, because it stretches patience beyond dignity, because it reminds us that fairness is not only about what is decided, but when. Most people encounter justice long before they ever think of courts. They encounter it in cues, forms, counters, and decisions that arrive quietly, in everyday interactions where no judgment is pronounced, but outcomes are felt deeply. A file moves, or it does not. An application is acknowledged, or it disappears into silence. A request is considered patiently or dismissed without explanation. In these moments, justice is not abstract. It is immediate and personal. For many, these experiences shape trust more than any verdict ever could, because they are frequent, because they are ordinary, because they repeat themselves over years, forming patterns that people learn to expect. There is a quiet hope people carry into such encounters. A hope that they will be listened to, that reasons will be given, that decisions, even if unfavorable, will feel understandable, that the process will feel fair, not arbitrary. Often, what hurts is not rejection. It is confusion, not knowing why something was denied, not knowing what could have been done differently, not knowing whether anyone truly considered the matter at all. When procedure feels opaque, justice feels. When discretion feels unpredictable, fairness feels fragile. People begin to rely less on explanation and more on guesswork, on assumptions, on stories they hear from others who have waited before them. There is an unspoken expectation in governance that power will pause long enough to hear, that decisions will not be rushed past the people they affect, that those who wait will be treated as participants, not interruptions. Even small gestures matter. Being asked to explain, being told what is missing, being informed of the next step. These do not change outcomes, but they change experience. When they are absent, people feel reduced, like obstacles rather than citizens, like paperwork rather than persons. This erosion happens quietly, without protest, but it accumulates over time. Discretion is unavoidable in administration. No rule can anticipate every situation. No guideline can capture every human nuance. So decisions are made by judgment, not just instruction. When exercised carefully, discretion feels humane. It allows flexibility. It accommodates difference. It recognizes context. It acknowledges that life does not always fit neatly into categories. When exercised carelessly, discretion feels arbitrary. It creates anxiety. It invites suspicion. It makes outcomes feel dependent on mood rather than merit. People begin to sense injustice, not because a rule exists, but because its application feels uneven. Because similar situations lead to different outcomes without explanation. Because fairness begins to feel like chance rather than principle. In such spaces, justice is experienced not through rights language, but through tone, through patience, through the willingness to listen before deciding, through the sense that one's presence is legitimate, not bothersome. Administration is where justice becomes routine, where it must be practiced repeatedly, quietly, without ceremony, where there are no final arguments, only ongoing relationships between institutions and people. This makes everyday governance powerful. Not in spectacle, but in influence. It shapes how citizens see the state, as responsive or distant, as caring or indifferent, as fair or exhausting. When people feel respected in small interactions, they are more likely to accept unfavorable outcomes. When they feel dismissed, even favorable decisions feel hollow. Because justice is not only about results, it is about process, about how one is treated while waiting. In this sense, justice lives in ordinary moments, in the way questions are answered, in whether silence is explained, in whether decisions feel reasoned rather than sudden. Courts intervene when these everyday systems fail, but they cannot replace them. They can correct extremes, but they cannot supply daily fairness. That work belongs elsewhere. Justice, for most people, is not something they seek dramatically. It is something they hope to encounter gently, without having to demand it, without having to fight for it, without having to travel far to find it. When governance gets this right, justice becomes almost invisible. Not because it is absent, but because it is present enough to be taken for granted. And perhaps that is its quiet success. Even when laws change, society often moves more slowly. Habits remain. Hierarchies persist. Advantages and disadvantages continue to pass quietly from one generation to the next, often without being named. Social injustice rarely appears as a single event. It appears as patterns, as repetition, as the same groups waiting longer, being heard less, being trusted less, as dignity offered conditionally, not naturally. For those who live within these patterns, injustice is not always dramatic. It is cumulative. It builds through small exclusions, casual remarks, lowered expectations, through the feeling of always having to prove worth again and again. Courts have tried at times to speak into this silence, to recognize that equality is not achieved simply by treating everyone the same, to acknowledge that historical disadvantage does not disappear just because rules change, to say that dignity requires attention to context, not blindness to difference. The Supreme Court of India has, over decades, interpreted equality as something deeper than formal balance. It has spoken of fairness as a lived condition, of opportunity as something shaped by starting points, not just finish lines, of dignity as something that cannot depend on social approval. Through its words, the court has often reminded the country that justice cannot be neutral in the face of inequality, that ignoring difference does not erase disadvantage, that historical exclusion leaves marks that law alone cannot wash away. These interventions have mattered. They have opened doors. They have offered recognition. They have signaled that the Constitution sees those who were long unseen, that it remembers history society might prefer to forget. But courts can only point. They can interpret. They can protect. They cannot transform society on their own. Social justice requires action beyond judgments. It requires institutions to respond, policies to adapt, resources to reach those for whom equality has long been theoretical. It requires patience, persistence, and political will. It also requires society to look inward, to question comfort, to acknowledge privilege without defensiveness, to accept that fairness sometimes requires adjustment, not uniformity. That equality may ask some to give up ease so that others can gain access. This is often where resistance appears, not in courts, but in conversation. In skepticism about claims of disadvantage, in fatigue with the language of justice, in the belief that enough has already been done. Yet for many, enough has never arrived. Opportunities remain uneven. Outcomes remain predictable. Dignity remains fragile. Recognition remains partial. Social justice is unsettling because it asks difficult questions. About inheritance, about power, about whose struggles are considered normal and whose are treated as exceptional, about whose voices shape rules and whose are asked to adjust to them. Courts have tried to frame these questions carefully, to balance competing claims, to hold together unity and diversity, to remind society that equality is not a threat, but a promise. But once the words are spoken, the work continues elsewhere. In classrooms, in workplaces, in neighborhoods, in everyday decisions that shape inclusion or exclusion. State action matters here, not as charity, but as responsibility, not as favor, but as correction, to ensure that rights translate into access, that recognition becomes reality, that dignity is not symbolic, but practical. Social justice also lives in how people treat one another, in whose presence feels welcome, in whose discomfort is acknowledged, in whose stories are believed without excessive proof. Law can create space for these changes. It can protect the vulnerable. It can signal direction, but it cannot compel empathy. It cannot legislate imagination. It cannot replace social effort. Perhaps this is why social justice always feels unfinished, because it must be renewed in every generation. Because each era inherits inequalities it did not create, but must still address. Because justice, once achieved in one form, reveals new gaps in another. Courts help us see these gaps. They hold up a mirror. They remind us of the promises we have made to ourselves. But their reflection only matters if we respond. Social justice, then, is not a destination reached by verdicts. It is a continuous movement, carried forward by institutions, policies, and people, guided by law but lived in society. And it asks something quietly demanding of all of us, not applause, not agreement, but attention. The willingness to notice who is still waiting, and the patience to keep walking toward fairness, even when the path feels long. Not every conflict needs a winner. Some need understanding. Some need space to speak. Some need a way to move forward without leaving deeper wounds behind. In everyday life, many disputes are not about proving someone wrong. They are about relationships strained by misunderstanding, about words spoken in anger, about expectations unmet, but not irreparable. For such conflicts, the language of accusation often does more harm than good. When people are pushed into opposing sides, they defend positions rather than explain feelings. The dispute hardens. Resolution becomes distant. This is where justice takes on a quieter form, one that listens before it decides, one that asks what repair might look like instead of what punishment is due, one that values closure over victory. In many parts of India, this idea has found expression through forums like the Lok Adalat, spaces where disputes are settled not by argument, but by agreement, where emphasis is placed on dialogue, compromise, and mutual consent. People come with stories rather than strategies. They speak of inconvenience, hurt, confusion. They are encouraged to listen, not just to respond, to see the dispute not as an enemy, but as a shared problem. The outcome may not feel perfect to either side, but it often feels acceptable. And sometimes that is enough, because peace, even if imperfect, allows life to continue. Mediation works in a similar spirit. It creates a pause in conflict, a moment where the goal shifts from winning to resolving, where an impartial presence helps people find words they could not find on their own. What matters here is not authority, but trust, not command, but consent. The sense that resolution has been chosen, not imposed. That dignity has been preserved, even in disagreement. These processes recognize something important, that justice is not only about right and wrong. It is also about repair, about restoring communication, about preventing small disputes from becoming lifelong bitterness. They also acknowledge emotional reality, that anger often hides fear, that stubbornness often hides hurt, that people want to be heard before they are judged. Unlike adversarial proceedings, these spaces allow vulnerability. They allow pauses. They allow silence to be part of the conversation, not an interruption. They move at human pace. This does not mean such methods are always appropriate. Some harms demand firm response. Some injustices require clear accountability. But where relationships matter, reconciliation can be a form of justice in itself. When disputes end this way, people often leave lighter, not because everything is resolved, but because something has shifted, because the conflict no longer owns their future. Justice here is experienced as relief, as release, as the ability to return to ordinary life without carrying resentment forward. These forms of resolution remind us that justice need not always be dramatic. It can be quiet. It can be practical. It can be kind without being weak. They also remind us that law can create spaces for humanity, that systems can be designed not only to decide but to heal, not only to conclude but to continue relationships with care. In a world accustomed to confrontation, this gentler justice often goes unnoticed. But for those who experience it, it feels deeply real, because it meets them where they are and helps them leave conflict behind without losing themselves. There are moments when a judgment is delivered, and yet something remains unsettled. The law has spoken. The process is complete. But feeling of justice does not arrive with the final order. In these moments, people do not always question legality. They sense something else, a quiet discomfort, a feeling that what is lawful may not fully align with what feels fair. This discomfort is not rebellion, it is ethical unease. The recognition that rules, however carefully written, cannot anticipate every human complexity. That life often presents situations too tangled to be resolved cleanly by principle alone. Courts themselves have, at times, acknowledged this boundary. Judges have spoken gently of the limits of what law can do, of situations where equity strains against strict interpretation, of outcomes that are correct in law, but heavy in conscience. Such acknowledgments are not admissions of failure. They are signs of humility, an awareness that law is a human instrument, structured, reasoned, necessary, but not omniscient. The law must draw lines. It must decide. It must conclude. But morality does not always conclude so neatly. It lingers. It asks questions that judgments cannot answer. There are cases where harm has occurred, but remedy feels inadequate, where responsibility is diffuse, where accountability cannot be placed cleanly on one's shoulder, where loss cannot be undone, only recognized. In such situations, people search not for reversal, but for meaning, for acknowledgement, for a sense that suffering has been seen, even if it cannot be corrected. When this recognition feels absent, justice feels incomplete. The Supreme Court of India has sometimes paused at this edge, speaking of conscience, of fairness beyond formula, of the sadness of certain outcomes, even when unavoidable. These moments reveal something important. They show that justice is not always triumphant. Sometimes it is restrained. Sometimes it is resigned. Sometimes it does what it can, knowing it cannot do everything. This honesty matters, because it prevents us from expecting the law to perform miracles, from placing moral burdens on institutions that were designed for resolution, not redemption, from confusing legal closure with emotional healing. Ethical discomfort often arises when people expect the law to carry values it cannot fully contain: compassion, forgiveness, redemption. These lie partly outside legal structure. When courts acknowledge this, they are not stepping away from justice. They are protecting it from being overstretched. They are reminding society that fairness is a shared responsibility, not a delegated one. These moments also invite reflection on our own expectations, on why we look to verdicts for moral satisfaction, on whether we sometimes seek answers from law that belong elsewhere. Justice in these spaces becomes a conversation rather than a conclusion, between legality and morality, between rule and compassion, between what can be ordered and what must be lived with. There is quiet dignity in this tension. It keeps the law grounded. It keeps society alert. It prevents certainty from becoming arrogance. At night, when people replay such outcomes, they rarely debate doctrine. They feel the weight of unresolved questions. They sense that justice has boundaries, that some wrongs cannot be neatly repaired, that some fairness must be carried forward through memory, not remedy. This recognition does not weaken justice. It deepens it. It reminds us that justice is not a machine that outputs satisfaction. It is a human endeavor, marked by limits, guided by conscience. Perhaps this is why justice continues to trouble us. Not because it fails, but because it refuses to be simple. Because it asks us to live with complexity. Because it leaves room for reflection, even after the law has spoken. And in that quiet space between legality and moral fairness, justice becomes something we must continue to think about, not to resolve it, but to understand it patiently, honestly, and with care. Justice does not belong only to institutions. It also lives quietly in how people treat one another, in everyday choices that rarely feel political, but slowly shape the moral texture of public life. Democracy asks something subtle of its citizens. Not constant action, not loud participation, but a willingness to share space with difference, to pause before reacting, to allow others room to exist without fear. Much of justice depends on restraint, on deciding not to misuse advantage, on choosing patience over impulse, on recognizing that disagreement does not require hostility. These decisions are rarely noticed. They do not make news. They do not feel heroic, but they accumulate, quietly strengthening or weakening the idea of fairness in society. When people wait their turn, when they listen without interrupting, when they follow rules even when no one is watching, they are practicing justice in its most ordinary form. Tolerance is not passive. It requires effort. The effort to sit with discomfort, to accept that others may think, speak, or live differently, to resist the urge to dominate shared spaces. Empathy, too, is a form of justice, not because it solves disputes, but because it softens them. It reminds people that behind opinions are lives. Behind arguments are histories. Behind anger is often hurt. In public life, this matters deeply, because democracy is sustained less by agreement and more by coexistence, by the ability to disagree without dehumanizing, to contest without destroying trust. Civil society plays a quiet role here, not as a movement, but as a presence. In neighborhood groups, in informal conversations, in shared efforts to address common concerns without waiting for orders. These spaces allow people to practice responsibility together, to resolve small conflicts before they harden, to notice problems early, to care without claiming authority. Participation in this sense is not about constant engagement. It is about attentiveness, about noticing when someone is excluded, when a process feels unfair, when silence is covering harm. Often, the most meaningful participation is simply speaking up gently, asking a question, offering a reminder, creating room for another voice to enter the conversation. Justice depends on this shared vigilance. Not suspicion, but care. Not accusation, but awareness. The understanding that fairness cannot be outsourced entirely to systems. When citizens act without empathy, institutions strain. When empathy is present, institutions breathe easier, because many conflicts are softened before they reach formal thresholds. There is also courage in everyday justice. The courage to be fair when unfairness would be easier. To be patient when impatience feels justified. To be honest when shortcuts are tempting. These choices do not feel dramatic, but they protect something fragile: trust. The belief that society is not hostile by default, that one can move through public life without constant defense. Justice, then, is sustained by countless small acts, by people choosing decency over dominance, listening over winning, care over convenience. This does not mean ignoring wrongdoing or avoiding difficult conversations. It means approaching them without cruelty, without haste, without forgetting the humanity on the other side. In a democracy, justice is not a distant ideal. It is a daily practice, renewed quietly in markets, offices, streets, and homes, sustained by habits more than declarations. At night, when institutions rest, justice does not disappear. It continues in how people remember the day, in whether they regret harshness or take comfort in restraint, in whether they feel they treated others fairly, even when it was difficult. Perhaps this is the deepest responsibility democracy places on its citizens: not to be perfect, but to be mindful. To recognize that justice is not only something we demand, it is also something we owe. Every day, in small, almost invisible ways, somewhere between policy and practice, justice becomes personal. Not dramatic, not visible, but deeply felt by those who encounter it through decisions made quietly, often without witnesses. Administration lives in this in-between space, where rules meet reality, where discretion fills the gaps that no guideline can anticipate, where judgment is exercised not in theory, but in moments that pass quickly and cannot be revisited easily. A file approved a little sooner, a hearing granted a little more patiently, an explanation offered when silence would have been simpler. These moments rarely feel significant at the time, yet for the person on the other side, they linger. Small decisions travel far. They shape trust. They shape expectation. They shape how people speak about the state long after the moment has passed. Discretion is not power alone. It is responsibility. The responsibility to notice context, to recognize vulnerability without being patronizing, to apply rules without forgetting people. Compassion here is not softness. It is attentiveness. The ability to see beyond categories and timelines, to understand that delay, confusion, or rigidity can weigh more heavily on some than others. Fairness is often tested in ordinary situations, when pressure is high, when time is limited, when competing demands pull attention in different directions. In such moments, justice is not abstract. It is immediate. What makes these decisions difficult is not their complexity. It is their quietness. There is no applause for patience, no recognition for restraint, no record of empathy shown in a brief interaction. And yet, these choices accumulate. They become patterns. They create reputations. They influence how entire systems are perceived, not by design, but by experience. For those who administer, justice is rarely about grand gestures. It is about consistency, about explaining reasons, about treating people as participants, not interruptions, about remembering that authority is felt most strongly in its smallest expressions. There is also the weight of consequence. A decision taken today may outlast the person who made it. It may shape lives long after files are closed and transfers made. This awareness often comes quietly, much later. Justice in administration is not about being flawless. It is about being mindful, about recognizing that every decision carries a human echo, that behind every request is a life moving in real time, not in policy cycles. At night, when offices are closed, people replay these encounters. They remember tone. They remember whether they were heard. They remember whether the system felt distant or humane. For those who will one day sit on the other side of the table, this is the quiet inheritance. Not authority, not status, but influence. The influence to ease a burden or deepen it, to clarify or confuse, to dignify or diminish. Justice here is not enforced. It is practiced, repeatedly, often unnoticed, but never without consequence. And perhaps that is what makes administrative justice so demanding. It asks for steadiness without recognition, for fairness without applause, for compassion without sentiment. It asks that decisions be made not only correctly, but carefully. Not only according to rule, but with awareness. Because long after decisions are forgotten by those who made them, they continue to live on in the lives of those who received them. As the day winds down, justice feels less like an idea and more like a presence. Not always visible, not always named, but sensed in how the day unfolded and how it will be remembered. Courts matter. They stand where disputes end and reasons are given. They protect boundaries that should not be crossed. They remind power that it must explain itself. That presence remains important, steady, and necessary. But justice does not wait for courtrooms to open. It lives elsewhere too, in offices that decide quietly, in conversations that turn away from cruelty, in choices that favor patience over haste. It lives in behavior, in restraint, in empathy that is not announced, in trust that is built slowly through consistency rather than spectacle. Most days, justice is not tested in extraordinary moments. It is tested in ordinary ones, in how people are treated when no one is watching, in whether systems feel human or distant, in whether fairness feels possible without struggle. This is why justice endures even when institutions strain, because it is carried by habits, by expectations, by the shared belief that fairness is not optional, even when it is inconvenient. Justice survives through trust, fragile, easily shaken, but deeply needed. Trust that reasons will be given. That time will not be wasted carelessly. That dignity will be respected, even in disagreement. When this trust weakens, justice feels far away. When it is nurtured, justice becomes almost invisible, not because it is absent, but because it is present enough to be taken for granted. Perhaps justice was never meant to be dramatic. Perhaps it was meant to be steady, something we lean on without thinking, something we notice only when it is missing. At night, when arguments quieten and files are closed, justice does not end. It settles into memory, into how people speak of their day, into whether they feel lighter or heavier than before. And tomorrow, it will begin again. Not all at once, not everywhere, but in small ways, in shared spaces, in decisions that pass quickly, but leave long shadows. Justice lived daily asks very little. Only attention, only care, only the willingness to treat one another as though fairness still matters. And in that quiet willingness, justice continues. Unfinished, unresolved, but alive.